on good terms the history of Kashmir did give rise to apprehensions. And your Lordship has seen all the material. So, border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase it in, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the historical background or the plain text?
The context is that this read by itself, forget the history, this read by itself shows that in sub-article 1, there is a divide in the legislative list base aligned to not the constitutional general 7th schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. And a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And the history of this provision also tells us it may be difficult to find a logic in each of these because these were a political compromise. Why was the Constituent Assembly put there? That was a compromise. A lot of things are done to assuage ruffled feathers. There were two approaches. One was the jackboot, saying doesn't matter, things will settle down, don't agree to anything special for Kashmir. The other was the other extreme, saying if the legitimacy of the accession is being questioned and there is a popular uprising, accommodate that. This was the compromise. So one cannot search for too much logic. This was the compromise form. And we must therefore, the safest thing for a court, in my very respectful submission, as a matter of constitutional interpretation, are such provisions. And such provisions are essentially political, and I don't mean political in its pejorative sense. I mean it political as in its constitutional sense. The court has always said you must give it the widest possible meaning. In fact, Manoj, I'll give your lordship that passage. Justice Pandian, I think Justice Pandian, in his majority opinion, where he upheld the abolition of the privy purse, where your lordships upheld the abolition of the privy purse, he says that our constitution was meant to be flexible in these areas. I'll give your lordship the exact passage. The fact that the ground realities would change in Jammu and Kashmir and 370 would accommodate was not first recognized by your lordship in the Maqbul Damno case, which has been cited. The challenge brought where Mr. Garg argued that without the Sadr Riyasat, you could not have the preventive detention law. And your lordship said state means state as exists from time to time. That is, my lord, already there. I'll give your lordship the passage. 72-1 Supreme Court cases, 536.
You have given us para 28.
It's there, my lord. It's volume 1 CLC
and
PDF.
Para 28 there.
Para 28. So, this was already one example of how this evolved. And that, my lord, backs in with a principle of construction. Your lord, the attorney just cited the presidential reference case, which says, well, if there is a requirement, then if there is a constituent assembly, you must get the recommendation. But if there is no constituent assembly, are you denuded of the power? And the presidential reference, my lord, the attorney just gave your lordships a moment ago. The judgment based on a passage on impossibility. And your lordship cited with approval Craze on Legislation, the 6th edition, in the presidential reference. The attorney just gave it.
Yes.
I have, my lord, for your lordship's assistance, given the 9th edition of Craze. I believe it's attached to my submissions. There's some slight interesting change in the text. I believe it is at PDF page 37.
Mr. Salve, which is your compilation of it?
Well, it's. I believe it has been given along with my note.
Is it along with the note itself?
Yes. This is, my lord, from the 9th edition of Craze. It's called Disregarding the Impossible. Para 8.2.9. It is appended to the note.
What page did you say, Mr. Salve?
Page 37 PDF.
Yes. Disregarding the impossible.
Yes. Yes. There's a slight difference in text from what your lordships approved, and in fact, it's even more instructive. It says one of the ancient maxims of common law is lex non causa ad impossibilia. As Broom's legal maxim puts it, the maxim, or as it is expressed, impotentia excusat legem, must be understood in the qualified sense that impotentia excuses, where there is a necessary or invincible disability to perform the mandatory part of law or forbear. It is akin to the maxim of the Roman law, nemo tenetur ad impossibilia, which, derived from common sense and natural equity, has been adopted and applied by the law of England under various and dissimilar circumstances. The result of the application of the maxim, which remains potent, is that the draftsman need not expressly excuse that compliance, which is obviously impossible. So, for example, if requiring a particular communication to take the prescribed form, the draftsman need not generally state that the requirement can be lawfully ignored where no form has been prescribed for that purpose. There may be occasions, however, where the sense of the legislation makes it arguable that the primary provisions are not to operate at all until certain mechanisms have been put to place by subordinate legislation. If the draftsman thinks it is necessary to avoid a suggestion of that kind, he will generally qualify a reference to the prescription by, if any, of that kind. So, my lord, the principle is very interesting. In fact, we have used it in a different branch, my lord. In service law, for example, we've used it all the time. It says your promotion will be as per rules. Now, if no rules are framed, doesn't mean you won't get a promotion. then you follow whatever is the general principle. But if there are rules, they must be strictly followed. Oh, my lord, this was the argument in this court. Of course, I went through the judgment. It didn't get to that point of deciding it. The old section 80J, rule 19(1)J, and the argument was, for example, if it says deduction of capital employed, if there are rules, you follow them. If there are no rules, doesn't mean the exemption fails. But there are other provisions which says you will get such other deductions as rules may provide. And that you can't operate unless there are rules. So we have had these two formats. And that is why we come back to why did the framers of the Constitution not say that if the President receives a recommendation from the Constituent Assembly, then he may. And instead say the President may abrogate this article, provided if he gets a recommendation from the Constituent Assembly. Which there is one, you must get the recommendation, otherwise. Now, this was also made.
Just 1 minute.
I'm sorry.
As you can see on your screen, Senior Advocate Harish Salve has, over the last few minutes, begun his submissions in support for the abrogation. We're going to wait for a few minutes. I believe he is, as you can see, shuffling through papers. He's begun his submissions for one of the parties in this case, supporting the abrogation of Article 370. He had earlier said that he'd made a 3-page roadmap of what he was going to be submitting. Remember, the Supreme Court continues to hear a batch of petitions challenging the abrogation of Article 370 of the Constitution that, remember, accorded special status to the erstwhile state of Jammu and Kashmir. Now, the petitions challenge a presidential order, that is, remember, the revoking of the special status that took place on August 5th, 2019. A 5-judge constitution bench, one that comprises of the Chief Justice of India and the Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gawai and Surya Kant, they're hearing the pleas on a day-to-day basis. During the previous hearings, Solicitor General Tushar Mehta had argued that any change in the Constitution that brings everyone at par can't be faulted. He also made what he had described as a positive statement a few days ago, earlier today, when he said that the centre was ready for elections in Jammu and Kashmir. This came after the bench asked the centre for the first time on Tuesday to specify a time frame for the restoration of electoral democracy in the erstwhile state of Jammu and Kashmir. They said that the present arrangement in Jammu and Kashmir has to come to an end.
I think perhaps we'll just wait for a second, Mr. Yes, Mr. Salve. Mr. Salve? Voice is perhaps, for a moment he was...
No, Malad.
Yes, Mr. Salve.
Yes. Can your Lordship hear me, Malad?
Yes, we can hear you now.
Yes. Finally, Malad, look at one important nuance of this article.
Yes.
In subclause D, of clause B. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the present law specifies. So, power to the president to apply or disapply provisions of the constitution or apply them with modifications. And this does not require unlike B1, that is the spread in the list, concurrence is not called for.
Let's look at it now, Mr. Salve. Let's see that again. I don't.
Yes. If your lordship sees 372(1)(b), 1 is the spread, my lord, of the list. Small subclauses 1 and 2 is
corresponding to the IOA.
Yes.
That requires consultation.
That requires concurrence. That comes in through the first proviso.
B.
Proviso, no such order which relates to
requires concurrence.
Yeah, B1 requires concurrence, consultation.
No, consultation.
Correct, my lord? And no such order which relates to matter other than those referred to shall be in the concurrence of the government. So this was built in. This dichotomy was built in there itself. Now, two things, my lord, your lordship will note. Applying or disapplying provisions of the constitution.
No, Mr. Salve, I could not get this argument.
Yeah, yes. May I just restate the point, ma'am? Clause D relates to not 370 but other provisions of the constitution.
Absolutely.
And they can be applied, disapplied, or with such modifications as the president considers appropriate. And that is with the concurrence of that government.
Yes.
Correct, madam? And sub-article 2 says, is the concurrence referred to in paragraph 2 of B of clause 1, such other matters, or in the second proviso, that is, my lord, would be D, be given before the Constituent Assembly for framing of the Constitution, it will be placed before the Assembly for such decision as it may take thereon. So, this was meant to operate much beyond the Constituent Assembly also, because that concurrence would continue forever. There would always be a state government. But state government, what that state government is another matter. There would always be a state government. But disapplying 370 was carved out and put in 3. Now that can't be a provision limited in time to the existence of the Constituent Assembly. And that is what explains perhaps why the recommendation rather than concurrence.
Mr. Salve, your voice was cracking just a little bit, when you were making this, the last part of your argument.
Yes.
Maybe.
I'll repeat it, Marat.
Yeah, if you could.
Disapplying 370 itself comes under sub-article 3.
Right.